The defendant is ready for cross-examination.
Thank you, Your Honor. All right, Mr. Jimmy Bob Joe Jr., what's your favorite color?
Objection. This is irrelevant to the case.
And what is your backing up?
I just wanted to know his favorite color.
Sustained.
So as you saw in the video, the prosecutor asked an irrelevant question to Mr. Jimmy Bob Joe Jr. here, and there was an objection by the defendant, and that was sustained by the judge. So therefore, the question was not open.
Both lawyers must follow strict rules of evidence in making their presentation. Among other things, these rules specify what kinds of questions the lawyers may ask witnesses. If either lawyer appears to break a rule of evidence, for example, by asking the wrong kind of question, the other lawyer may interrupt by making an objection. An objection stops the questioning and brings the problem to the judge's attention. The objecting lawyer tells the judge what rule he or she thinks the first lawyer has broken. The lawyer accused of breaking the rule has a chance to defend the question he or she asked. The judge then decides whether to overrule, not permit, the objection or sustain, permit it.
If the judge sustains the objection, the objecting lawyer must ask the judge to strike the witness's answer. If the judge agrees to the request, the court reporter must remove the witness's answer from the transcript of the trial. The members of the jury are instructed to pretend that they never heard the witness's answer. They are told to disregard it when they are deciding the case. It is each lawyer's responsibility to know the rules of the evidence and make sure the other lawyer follows them. If either lawyer breaks the rule of evidence, the judge may ask the lawyer to rephrase his or her question. More often, however, the judge will remain silent unless the other lawyer objects. The defendant is ready for their cross-examination.
Thank you, Your Honor. Mr. Jimmy Bob Joe Jr., what is your favorite color?
Yellow, because it's bright and sunny. Objection. That is irrelevant to the case.
What is your reasoning?
I just wanted to know his favorite color.
Sustained. Wipe that from the transcript and jury, forget that. Never happened. In this instance, the defendant answered the question before the other person had time to object it, so we had to have the judge strike it from the transcript and make sure that the jury knew not to include that in their final decision. We are ready for closing statements.
Thank you, Your Honor. Ladies and gentlemen, the defendant, Mr. Jimmy Bob Joe Jr., is guilty of stealing the beaver because we found beaver fur in his house and there are bite marks all up his arms. He is guilty.
Actually, clearly our defendant is innocent because the reason he has bite marks of his arms is because he works at the zoo and he aggravated beavers when he was feeding them. And that wasn't beaver hair in his house, it's his dog. So clearly he's innocent.
As you saw in the video, each lawyer was allowed to make their closing statement, which summed up each side of the case.
After both lawyers have completed their presentations, each lawyer has a chance to sum up his or her side of the case. These summaries are called closing statements. Usually the plaintiff's lawyer or the prosecutor goes first. The defendant's lawyer makes the second closing statement. Then, in some jurisdictions, the plaintiff's lawyer or the prosecutor is permitted to speak once more.
Each lawyer uses the closing statements to remind the jury of evidence that supports his or her side. Each lawyer also draws attention to the weak points on the opponent's case. He or she may try to cast doubt on whether events could have happened the way the other side claims they did. Because closing statements are the last thing the jury will hear, they tend to be more forceful and emotional than opening statements.